Hi, I'm Michael Schmitz. The goals for this talk are: how can the law be characterized from the point of view of a theory of collective intentionality, specifically from a layered account of collective intentionality and a collective acceptance account of institutional reality? And can this shed new light on traditional issues in the philosophy of law, for example, those surrounding legal positivism and the relation between law and morality? Now, what do I mean by legal positivism? I take the core claim of legal positivism to be whether something is law does not depend on its moral merits, but on its sources and the social processes that bring it about. It depends on a positive norm. It depends on institutional reality. There's no necessary connection between law and morality, and no natural order that necessitates the legal order. And so that means the law can be immoral and still be the law. Now that seems an admirably naturalistic perspective, and to my mind at least, as clearly correct as long as one takes an observer perspective on the law, but not on morality. But what if one takes into account that moralities can be immoral too? What if we take an observer perspective on the law and on morality? Can the laws of a society really be independent of the morals of the members or co-subjects, as I like to call them, of that society? For example, could the Jim Crow laws or Nuremberg laws have been the law if the moral attitudes had been as they are now? Hardly. But what dependence of the law on morality is compatible with legal positivism? Is legal positivism compatible with a collective acceptance account of legal reality? So let's look at the collective acceptance account of institutional reality, of which legal reality is a part. Now, at least John Searle later said institutional reality is intentionality relative and not observer relative only, as he said in his early writings on this. That means that belief that something is the law, or that something is a legal official or something like that is not sufficient for the existence of legal reality. It also requires a practical acceptance, a degree of identification with the legal order. I think, to me at least, this also means that the account of institutional reality in terms of declarations is not optimal, but it's better to think about it in terms of push-me-pull-you representations, what Ruth Millikan calls push-me-pull-you representations, for example, like, we don't eat peas with our fingers here. Now, a declaration says we make something the case by saying it is the case. So by saying that somebody is a legal official, by saying that something is a law, we make it the case that something is the law. And so that means we have mind-to-world direction of fit attitude and world-to-mind direction of fit attitude regarding the same state of affairs that's stated to be the case and brought about to be the case. And that is at least a questionable idea. In contrast, the idea of a push-me-pull-you representation seems initially similar because it also has both directions of fit, but not, and that's a crucial difference with regard to the same state of affairs. Now, it's not that we make this, observe the same state of affairs and make it the case at the same time, but the basic or naive attitude towards the law is we do have a mind-to-world direction of fit apprehensions of its existence, and at the same time we have a world-to-mind acceptance of its normative force, which is not yet clearly separated from this. So in a way, accepting its existence is not clearly separated from accepting its normative force. And that's the usual understanding we have, for example, when we say something like, we drive on the right side of the road. That means that's the way to do it. So a clear separation of existence and normative force only happens on a higher level of reflection. But it seems to me that the basic attitude is like the normal default attitude that we have in everyday dealings with the law, and it's crucial to its functioning. So think from this, we should go even further, namely from the idea of collective acceptance to what I call co-subjective consciousness. And that means we must accept rights and obligations and so on, which determine institutional statuses in general and legal statuses in particular, with others as co-subjects of the legal orders. That is, we accept certain things in the role that we have in this legal order as a citizen, for example, or as an official, and we take theoretical and practical position towards the world as role bearers in role mode. For example, as a citizen, I applaud the decision of the court. So in my role as a judge or other legal officials, I decide that such and such is the case, or I decide to do certain things. And it's crucial also that positions taken in these roles may differ from those taken in I mode or as a private person. For example, as a citizen, I may applaud the decision of the court, even though maybe for me as a private person, it's not even favorable. And in my role as judge, I may make a certain determination, even though I may think differently about it as a private person. Now, for purposes of rough orientation, I think we can distinguish three layers of co-subjective consciousness. First layer is the joint sensory-motor emotional intentionality, where we have joint attention, action, emotion, attendant dispositions, and non-conceptual experience of others as co-creatures. Then we have the level of we-motor intentionality, where we have beliefs, intentions, moral values, and other values that we share with co-persons. And at that level, we have conceptual thought and spoken language. And we have role mode intentionality, where individuals and groups take positions as co-role bearers in legal and other institutional contexts. And I think that requires writing and documentation, at least for more elaborate legal systems. This rough orientation can be precisified if we rely on certain criteria for a taxonomy of layers in terms of representational format, when we distinguish such properties as richness of content from concrete to abstract, degree of context dependence, a density differentiation of representational role, and degree of durability and stability. And I think these properties cluster and are connected to role differentiation in a society. So if we have a lot of role differentiation, we have lawyers which codify, systematize, and differentiate legal rules and create ever more complex legal systems. Now, what are the relations between these layers? The idea is the higher level intentionality only determines COS, conditions of satisfactions, against the background of a lower level. And so we have this hierarchy of institutional functions against the background of a conceptual level functions against the backgrounds of non-conceptual level is transitive, so ultimately institutional level also functions against the background of non-conceptual level. The application to laws, legal rules can only be applied and determine conditions of satisfactions against the background of shared morality and common sense. So example, a legal rule forbids to take a vehicle into a public park, but what does vehicle mean here in this rule? And at this point, even the famous legal positivist Hart said moral considerations, common sense play a role in answering this question. Another point is then when parts of the legal order are too removed from the shared morality of a society, they may cease to be applied, for example, as certain laws against sodomy or oral sex in some US states, or they may not be accepted anymore. For example, the speed limit in the GDR a few days after the fall of the Berlin Wall, as I experienced myself, even though legally nothing had changed, nobody was paying attention to the speed limit anymore because the moral standing of the state had been eroded. And of course, ultimately, they may be removed, the legal order may be removed and overthrown. Now, back to the question of legal positivism. Does the dependence of the legal order on collective acceptance in the role mode and on lower level intentionality for application of the rules threaten legal positivism? Because if this is correct, morality is crucial for both determining application and conditions of satisfaction and determining collective acceptance. Now, one problem here is that collective acceptance is admittedly a vague notion. And I think we must try to make it more precise, but at least at this point, I have to say, I find it hard to imagine it has no application. One precisification we can give here is it is holistic. We may accept a legal order even if we do not accept all its rules. Another precisification is a legal order may be imposed on a population which are merely its objects. For example, this arguably the case in an occupation, and that's not really what I'm talking about. I'm talking about here about a society of co-subjects. Acceptance is a political question, and I think there's evidence that moral attitudes determine political choices. Maybe in some sense, I'm tempted to think it's kind of obvious that is the case. So again, the question, is this inconsistent with legal positivism? Now, I think that's not necessarily the case, because you can certainly define a version of legal positivism that's consistent with it. But I think there are problems with some of the responses that legal positivists have given to this question. So I think there is certainly need for further clarification. So let's go through some of these responses. The first positive response is legal officials do make use of moral considerations in applying statutes, but that's not a problem for legal positivism, because that does not make morality part of the law. Now, it seems to me it does not really make sense to separate the law from its applications. So if morality is essential to applying the law, it seems to me it's just simply essential to it. So it seems to me that's not a satisfactory response. The second positivist response is whether and how moral consideration enter into the application of the law is itself determined by legal rules. Now, there are so many different ways in which morality will shape our understanding of the law, and so many different places where moral considerations can enter into it, that seems to me it's implausible that the law can and does determine all of them in advance. And how is it supposed to do it? So it seems to me that's not a satisfactory response either. The third positivistic response is to say the internal point of view, as it's been sometimes called following Hart, only applies to the legal officials. Now, I think there may be a specialized understanding of the internal point of view in which it only applies to legal official, but I think this response is not plausible if it should mean that non-officials do not have any sort of identification with the legal system. I think people are invested in the legal system. They do identify with it. And so if non-officials lose all the trust in the legal system, they will cease to accept it. Now, the fourth positivistic response, and that's specifically a response to a Weberian or Searlean acceptance account, like I have discussed, is to say, even if there's a nomenological connection between moral attitudes and the legal system, there is no necessary or metaphysical connection. For example, it might still be conceivable that technology might ensure dominations of a legal system, even if it's not accepted by the population in any conventional way. Now, it seems to me that's also sort of missing the point, it seems to me, because some kind of science fiction sort of technological scenario of controlling the population through technology, that's not what we mean by saying when we say a legal system is accepted in a society. I don't think that's what we mean when we talk about governing people, and that's not the rule of the law as we value it. So, in conclusion, let me suggest, might law indeed be institutionalized morality? I think there is a need for further clarification here with regard to the question that I've addressed, but perhaps ultimately it does not matter so much if a layered acceptance account, if that is the correct account, should count as a form of positivism or not. But it seems to me there's nothing magical that happens to a moral rule when it is codified and enforced by specialists. So if that picture that I painted is roughly correct, it seems to me it's more like the law is continued with morality somewhat in the way that science is continuous with ordinary knowledge. And I think then it might even be true that the best way to look at the law is as itself being a form of institutionalized morality. Thank you very much.